Good afternoon, everybody. It's great to have so many people here. We have law enforcement, victim advocates, and tribal court judges. Today we are doing a tribal court EPO training just to make sure everybody's in the right place. You all should have gotten a link for the program materials in an email. If you didn't, I believe Jake did put that in our chat, so you also have the link there. I'm going to introduce everybody, and then we're going to get started with our presentation. We've got a lot of material to cover, so hopefully once we get rolling, it just goes super smoothly. First, I want to really thank Cynthia Boschel from the Northern California Tribal Court Coalition and Jake Swamp. They have handled the logistics of this training beautifully, and we would not have been able to put it on without them. So thank you both. And as far as our presenters today, we're going to start with Maggie Fleming, who's been the DA here in Humboldt County for 7 years, but she's been a prosecutor for over 30. During the time that she has been the DA, she's kept the DA Roundtable going, which is a local group that allows tribal communities to meet with the district attorney and state law enforcement representatives to talk about any law enforcement issues that are going on. And that has been especially helpful when it comes to protective orders, because those are, they are just an ongoing need in communities. The Sheriff William Hansel, is also going to be co-presenting with the district attorney. He's been the sheriff for more than 3 years, and in the time that he has been sheriff, he's been open to meeting with tribes to address concerns about law enforcement. We're really fortunate to have 3 judges as presenters today. Judge Abby Abinanti is a member of the Yurok tribe. She graduated from the New Mexico School of Law and is the first tribal woman to be admitted to the California State Bar. She was a San Francisco Superior Court Commissioner for over 17 years, during which time she was assigned to the Unified Family Court, which was family dependency and delinquency. In 2007, Judge Abinanti began hearing cases for the Yurok Tribal Court, and in 2011, she was appointed the chief judge. She's also the judge for the Bear River Band of the Ronerville Rancheria Tribal Court and hears cases for the Hoopa Valley Tribal Court. Judge Abinanti issued EPOs for law enforcement during her time on the San Francisco bench, and she has been a strong advocate for tribal courts establishing EPO procedures. It has been years that she has been encouraging us all to move forward in this direction. Presenting with Judge Abinanti is Commissioner Rebecca Whiteman. She has served as a family law commissioner for the Superior Court of San Francisco County since 2000, hearing cases that include child support, custody and visitation, and judicial settlements. She previously worked as a commissioner, temporary judge, traffic and discovery referee, and juvenile court hearing officer for the Superior Court of Marin County. During her time on the state court bench, Commissioner Whiteman has not only issued EPOs, but she has also had the responsibility of training other bench officers on how to issue EPOs. So we are just really fortunate to have her here today, because she has given her time and expertise for this presentation. She, just so everybody knows, she put together the EPO slides that you're going to see, as well as the judges and law enforcement EPO packets that were provided to you all. Just thank you so much, Commissioner Whiteman. It's a huge honor to have you. And Judge Abinanti and Commissioner Whiteman worked together in the past to train state court judicial officers, law enforcement, and victim advocacy programs on EPO issues during their shared time on the San Francisco bench. So they're kind of together again to continue the good times. Judge Leona Colgrove is a graduate of the University of Washington School of Law with a concentration in alternative dispute resolution. Judge Colgrove is the elected chief judge for her own tribe in Hoopa, the chief judge of the Quinault tribe, where she is a descendant, and the chief judge of the Elk Valley Rancheria. She has been practicing law since 2000 and began her judicial work in both tribal and state court in 2006. She has extensive experience hearing child welfare and family law matters. In addition to her judicial work, Judge Colgrove is an active attorney and has litigated on behalf of victims in both tribal and state court. She was the first Indian judge to sit on the Washington State Supreme Court Commission on Children in Foster Care. In the 3 years since her election in Hoopa, She's expanded victim protections and services by developing a victims of crime program on the reservation. In addition to developing procedures and forms necessary to issue EPOs, Judge Colgrove has secured funding for an advocate and legal aid to serve victims in the community. She's held positions on the Washington State Tribal Court Judges Association Governing Board, as well as the National American Indian Court Judges Association's Executive Board. She currently sits on the California Tribal State Court Forum, as well as the Washington Tribal State Court Consortium. And after our esteemed judges and the DA and sheriff have spoken, Cynthia Boschel of the NCTCC is going to go over an app that is very useful for victims of domestic violence. It has a ton of local resources as well as national resources for victims. Cynthia has been the executive of the NCTCC for some time now, and she has really devoted herself to tribal issues and educating the community. So thank you very much. And with that, I'm going to hand it off to DA Fleming and Sheriff Hansel.
Great, thank you all. And thank you so much for inviting us to participate. I think this is really an outstanding idea for us to share information and for this training to be available and recorded so that we can use it ongoing for law enforcement trainings. So thank you so much for including us. So the first slide, I just wanted to sort of touch upon the types of protective orders that law enforcement are going to see. And these are from non-tribal court jurisdictions. So we have emergency protective orders, we have ex parte restraining orders, and then there are what are called order after hearing. So for our orders to become more than just a temporary restraining order, there has to actually be a hearing where witnesses testify, and then ultimately there's a OAH issued. If we file criminal charges, we have two options for restraining orders. We can get one pending trial, and then after the case is completed and the person's convicted, we have the ability to then seek a protective order that requires the restrained person to stay away from the victim. With regards to the enforcement of these protection orders, I cited the California Family Code sections. The order is valid when we can show the restraining order or the protective order identifies the protective individual and the respondent, that it's currently in effect, so it has to be still valid. And this is something we ask sometimes when law enforcement calls us from the scene and says, we're here, we're looking at the order, but I don't see a date on it. We'll go through with them and discuss where are the dates, is it still valid? That the issuing tribunal had jurisdiction over the parties, and then that the respondent was given reasonable notice and had the opportunity to be heard before the order was issued, or will have the opportunity to be heard within a reasonable time after the order. And then the last one, which is kind of critical, is that the respondent has been notified or served with the order. And I say that because sometimes, even though the individual was noticed of the hearing date and the person who's seeking the restraining order is in court and presents the information to the judge, and the judge issues that order, we then need to know that the person that has to stay away has somehow been noticed.
So sometimes we know that when we respond to violations or restraining orders or complaints, that there is a defense that the person didn't know about the restraining order or they weren't properly served, right? And so that's a part of our elements of our crime, making sure that they knew about it. So, when the notice of proof of service cannot be verified, number one, we can do that service as law enforcement. We can provide that service a notice. We would see it as a face value, a valid restraining order. We can put that person on notice that this is a valid restraining order. Inform the restrained person of the terms of the order, detail by detail, reading it to them is totally something that law enforcement can do. We can make a reasonable effort to serve that order, allow the person the opportunity to comply with the order. Once they know and it's verified that we went through it and they understand it, then give them the opportunity to comply with that order. And again, what are the consequences of that? If they do not comply or if they violate that restraining order, then they could be subject to arrest. Now, over the last, especially the last year, we've been kind of hamstrung with our pandemic guidelines in the jail, but our jail is open for service. And so we are even taking misdemeanors that are problems in our community. They still have the option to cite and release. for violation of the court order, but we can book those people in our county jail for violation of a court order or a restraining order. And so we understand that sometimes that is very necessary for someone who is harassing someone who does not want to comply with the restraining order. And it's our way of separating and holding that person accountable. And then they also have the opportunity, if their likelihood to reoccur, to hold that person in custody until they are arraigned. So that's it. Then once we do that documented service, we do have to write a report to document that and to send that to the court as our proof of service. So that's kind of a little bit about proof of service.
Sometimes there's conflicting orders, so we always like to let law enforcement officers in the field know, verify the validity of all the orders. If they're conflicting orders of the same type, so either both are from civil court or both from criminal court, the most recent order takes precedent. But the most important part is that the most restrictive terms take precedence over conflicting orders. And this comes up quite a bit because maybe in family law, that judge issued sort of a limited restraining order, but then once we have a conviction, for example, in domestic violence, we have a much more extensive restraining order. Literally they can't go to the school, perhaps they can't go, other places where they might run into the party who's afraid of them. And so that's what we always want to remind people is the most restrictive terms are what we enforce.
Right. It's important, I think, in law enforcement to prove these cases beyond a reasonable doubt. We need to document all the elements of the crime. And number one, that they did know about the violation, they did know the restraining order, they did know that by their action violated the restraining order, and making sure that we collect that evidence that is necessary to prove this case, so the district attorney can then prove their case in court. So it's our job in law enforcement to make sure that we do get the required paperwork, and a certified copy is better. But we don't need a certified copy to make the arrest, but to prove in court, we definitely do need that. And to provide witness statements. And even if we respond to the scene, and we know with domestic violence, sometimes we do have people that don't want to prosecute because of fear of retaliation. We can make those arrests, and we encourage our law enforcement officers to make those arrests when they do become aware that someone is violating a restraining order, whether it's from elder abuse, domestic violence. We understand there's a lot of intimidation that's going on out there, and so we encourage our law enforcement officers to make that arrest and so that protected person is truly protected, and then advocates can come in and do their part. So.
And that was what we wanted to cover, and thank you for giving us the opportunity to do that.
Hello, my name is Javier Becerra, and I'm the Attorney General for the state of California. The topic of this educational video is close to my heart. You see, I'm the father of 3 daughters and the brother of 3 sisters. And as a congressman, I fought to reauthorize the Violence Against Women Act to combat domestic violence against all women. What you'll learn in this video is important to each one of us because the rates of violence and abuse in our country are astounding and totally unacceptable. Domestic violence affects more than 12 million people in our country each year. In California, domestic violence homicides comprise over 10% of all homicides in the state. 4 out of 5 American Indian and Alaska Native women in their lifetime have experienced rape, physical violence, and are stalked by an intimate partner. Domestic violence is an epidemic, and we all can play a part in ending it. The issue that we are addressing today is the enforcement of tribal protection orders, a challenge faced by many tribal communities. This video and the information bulletin issued by my office will provide you with guidance on what to do when presented with a tribal court order. I urge judges, law enforcement officers, and all our justice partners to watch this video and use it at educational events. It will take all of us working together to prevent and end domestic violence. I'd like to thank the Judicial Council's Tribal Court and State Court Forum, the California State Sheriff's Association, and all our justice partners who paved the way for the solution that we are presenting in this video. Thank you all very much.
Hello, I'm Judge Abby Abenanti. I'm the Chief Judge of the Yurok Tribal Court, and the co-chair of the Judicial Council's Tribal Court State Court Forum. With me today is California's Chief Deputy Attorney General, Kate Canelli. We're very pleased to be here together presenting this very important public safety message about domestic violence. We depend on our tribal and state courts to hear domestic violence cases and to issue appropriate orders. And both courts depend on law enforcement to, when they see a protection order, whether it's issued by a tribal court judge or a state court judge, to enforce it immediately. We hope the information we have to share with you today will address a problem we're having in some parts of California. The following short video illustrates that problem.
Officer, excuse me. This man is following me, and that's a violation of a restraining order that I have against him.
Can I see this, please?
That paper is worthless, officer. It comes from a tribal court, not Superior Court.
And how do I know that this is a valid order, ma'am?
Well, you could call the court clerk, and they can tell you that it's valid. And also, it has a judge's signature, and then there's the court stamp right there.
Well, I'll have to call in to find out if this is valid. You wait here, ma'am. And sir, would you please wait over here?
Thanks to the leadership of California Judicial Council's Tribal Court State Court Forum, the California State Sheriff's Association, the Office of the Attorney General, and other justice partners, Judge Abenanti and I are here to tell you that the law is very clear when it comes to the recognition and enforcement of tribal protection orders.
Public safety depends on our courts, both tribal and state courts, to issue orders and law enforcement to enforce them. When that doesn't happen, the justice systems, both tribal and state, have failed our citizens. What follows can be devastating to the lives of our children and families. It creates situations where victims are re-victimized.
This is why we came together to address the problem. As a result of our collaboration, the California Department of Justice issued this information bulletin, which summarizes the law. You'll find a link to the information bulletin in the resources section of this video and other resources should you have questions or want to have further reading or training on the subject. Turning to the video you just watched, the information bulletin makes it very clear that federal and state law require the officer to enforce the tribal protection order on the spot. The law requires the officer to give the tribal court order full faith and credit. He should not be calling the tribal court to check the validity of the order, nor should he question the order because he doesn't recognize the tribal court. Again, the law is very clear on this point. The Federal Violence Against Women Act and California Family Code mandate that courts and law enforcement recognize and enforce protection orders from other jurisdictions as if they were issued in their jurisdiction.
So what if the officer says they won't enforce the order because they're not sure it's valid?
Well, as long as the order identifies the protected individual, the individual against whom the order is sought, and appears valid on its face, it's enforceable.
Okay, great, thank you. What if the officer says they won't enforce the order because it isn't a certified order?
No, the officer cannot require certification.
Okay, great. So what if the officer says they won't enforce the order because it's not registered or filed with the state?
No, the officer cannot require registration or filing.
What if the officer says the order isn't enforceable because the officer isn't able to verify that it's in the statewide database? Law enforcement practice has been to verify tribal protection orders through the California Law Enforcement Telecommunication System, the one we all refer to as CLETS. What we hear in Indian country is that law enforcement does not get a hit in CLETS. If they do not get a hit in CLETS, then the officer will not enforce that order.
I understand that that's been the practice in California, but the DOJ information bulletin is very clear about this.
So basically, a tribal court protection order must be enforced. An officer cannot require certification, registration, or verification in a statewide database like CLETS.
This public service announcement, introduced by the California Attorney General, is critical information for every law enforcement officer to understand and follow. My name is Sheriff Martin Ryan from Amador County. Last year, when I was president of the California State Sheriff's Association, I had the pleasure of working with the Judicial Council's Tribal Court State Court Forum, the California Attorney General's Office, and other justice partners to change how law enforcement responds to tribal protection orders. The problem we were having was that in some jurisdictions, Officers were checking to see if orders issued by the tribal courts were certified, registered, or verified in a statewide database like CLETS before they enforced them. I'm here to tell you that this is not the law, nor is it good law enforcement practice. Responding to domestic violence calls for service is one of the most volatile and dangerous situations for victims and police officers. They lead to about 14% of officer deaths every year, according to the FBI. It is imperative when officers respond to a domestic violence call, they recognize that they're walking into a potentially dangerous and unpredictable scene. Just like there is no such thing as a routine traffic stop, there is no such thing as a routine domestic violence call. Officers must approach each domestic violence case with the highest level of caution while maintaining an open mind and seeking ways to offer assistance and protection to the victims of such abuse. And when the victim has a protection order, whether issued by a state court or tribal court, it must be enforced immediately. If you are a law enforcement officer and would like resources for training on this topic, contact the Commission on Peace Officer Standards and Training, also known as POST, which was established by the legislature in 1959 to set minimum selection and training standards for California law enforcement. You will find a link in resources. If you're a judge from a tribal court or state court and would like resources for training on this topic, contact the Judicial Council's tribal state programs. They offer steps to justice domestic violence services focusing on tribal state county collaboration. At the request of a judge, staff will tailor an educational event to meet local educational needs or provide technical assistance in response to locally identified targeted needs. You'll find a link in resources. We hope you found this video helpful. Thank you for your attention to this very important issue.
And just to answer a potential question for law enforcement out there who doesn't know, the reason that tribal courts don't enter their orders into CLETS is there's no direct access. The order can be registered as an out-of-state order, but the tribal court, when it issues the protective order, does not have the ability to just enter it into CLETS like the state court does. If the tribal courts had that ability, it wouldn't be an issue. The orders would be entered into CLETS. And with that, we're going to shift gears now and actually talk about the EPO process through tribal courts. So I'm going to hand it off to Judge Colgrove, and after Judge Colgrove, Judge Abby and Commissioner Whiteman are going to take it.
So we have so much material. I'm going to be very, very brief. We have several of our officers on, and I wanted to just talk about what Hoopa is doing. So as Michelle pointed out, I've been a judge since 2006 and worked in many, many courts. And I will just tell you that we issue in Hoopa more protection orders than any court that I've ever worked in. And so that being said, although we've had the authority to issue EPOs through our code for a very long time, I have never seen one or heard of one having been issued. There were no forms in place when I took my position, my elected position, and the officers didn't appear to have been trained in the process. And so it clearly seemed that that was a missing piece and a need based on the numbers that we were looking at as far as protection orders in the community. So we stepped up and decided that this is something that we needed to move forward with. And so we are in the process following this training. We'll be putting out a memo for our police department, as well as a duplicative EPO form that will look very similar to the state court form. We've done that deliberately. All of our protection order forms are very similar to the state court forms. We just find that that makes it a lot easier for law enforcement to make them enforceable. One thing that I want to make clear to our law enforcement is that once we begin this process, we anticipate that you'll be giving us calls. We anticipate that we'll send you one phone number, and then that phone number will go first to one judge, and then if you can't reach one judge, it'll go to the next judge, and that will be myself or Judge Ferris. And we want to encourage you to call, whether it's, 1 o'clock in the morning, 2 o'clock in the morning, it doesn't matter. Our first priority is keeping victims safe. And so whenever you need to make that phone call to get an EPO, we encourage you 100% to make that happen. Thank you.
Welcome, everybody. This is Commissioner Rebecca Whiteman, and I'm so glad to see so many participants. This is great. I hope that this will be a useful tool down the road as well after today. And I'm going to be probably doing primarily a lot of the talking, but Judge Abby, quite frankly, is my inspiration, and she's been doing great things. And I'm so glad that she actually asked me to do this. I jumped at the chance. So what we're going to be covering today, if we are going to start our slide. We have a few goals we want to accomplish today. We've already accomplished the first, and the first goal was to have an important message regarding enforcement. And the next thing we're going to talk about generally is just a few domestic violence statistics. Even though you've heard them in the video, it bears repeating. We're going to talk about that very briefly. And then we're going to get to the meat of it, which are the emergency protective orders and the requirements, their assessment, the issuance, which will cover things including jurisdictional issues, gathering and understanding and communication of key facts back both the law enforcement side and the judicial side, filling out the EPO form. We're going to have sample forms for you we're going to look at, and then I'm going to touch on lethality and danger assessments, which are really critical. That if law enforcement doesn't have a program, I encourage them to consider putting one together, and we have some information for that. So we did have a slide. We're just going to pass over on the video that you saw. It bears repeating that there is no checking, no need to see if it's in a system, et cetera. When you get these protective orders or you see these, they should be enforced immediately. In terms of some background and statistics, DV's been around a really long time. But it wasn't until the mid-90s that the National Domestic Violence Hotline was established. And I'm astounded every year I check to see, the contacts that they get and the inquiries that they get. And it's now well over 500,000 just from 2 years ago. I checked again recently, and with COVID, it's actually gone up another 10%. The high-risk teams and lethality assessments that we'll be talking about briefly at the end, they've only been instituted in the past decade. But again, unfortunately, DV just continues to be on the rise. It's just going up and up. These numbers, as Javier Becerra indicated, they're staggering. And in terms of how often, and Jake, you can go to the next slide, how often they occur, every 9 seconds, there is an incident. 1 in 3 women experience violence in a lifetime. And in terms of American Indian and Native Alaskan, as you heard, 4 in 5. Vast majority of those are committed by non-native perpetrator. When you have the presence of a gun, that increases the risk of homicide for women over 500%. And it's even higher if there's been a strangulation incident. We're going to be talking about a little bit about that. The risk of death for American Indian, Alaska Native is 10 times greater. So these are just the ones, quite frankly, that are being reported. And domestic violence is really one of those most chronically underreported crimes. And we'll talk about that in just a moment. So what I wanted to do before we actually move on is just sort of have you all think about, as it relates to a victim and the level of risk or danger. I'm going to put up just 4 items, and I want you to just rank them in your own minds. What concerns you the most in terms of, again, as it relates to the victim and level of risk? Is it that they own a gun, or that the perpetrator owns a gun, that there's alcoholism involved, that they've been estranged, recently broken up, or that there's been a suicide threat? So if you think about that, I pretty much could guarantee you that everybody's going to say that in terms of the highest level of danger or risk is going to be the gun. And you're right about that. So you can just push one more, just one. Next, if you're, again, what you're thinking, the next level of danger really for a victim is when the parties who have been either former dating, whether they're married, unmarried, with children, is breaking up, being estranged. At that point in a relationship is probably one of the most dangerous other than the gun. Next comes the suicide threat. I'm going to kill you. I'm going to kill myself. Again, this past studies have shown that these are times at which the risk and the danger with regard to the victim and children are highest, and last becomes the alcohol. So what I'd like to do is talk just a little bit about, and I want to ask Judge Abby too, oftentimes a person doesn't even recognize the danger, and there are some barriers with regard to that. There are cultural barriers why victims don't report. Why is it so underreported? One of the things that's very important to understand for law enforcement, and judges, advocates know this in terms of being careful not to make any value judgments or assessments as to why somebody doesn't report. There can be a lot of reasons. Economic reasons. There can be fear for their own safety of the children. There can be geographical distance. These are just general lack of available and appropriate resources. But for Native Americans, it's even greater. And I want Judge Abby to speak a little bit about that.
Well, I think we all know that one of the big challenges in our region is the region itself. We are so far away from help and from support. We have a history of difficult relationships with some of the agencies who we're now partnering with, and who I feel are also working with us to overcome some of the issues that happened that our people hold in their minds. And one of the things I learned from our chief, which I found was very interesting, he asked me one day, what is the Yurok word for police? And I said, I don't think I know. And then he told me, and I said, what's the translation? And he said, the translation of that word is men who steal children. Because our first introduction to them were when they came and they took children and forced them away from their parents, either through indentured slave or through boarding schools. And when you have that kind of history and that kind of negativity, it's hard to overcome. And people need to understand that. And they need to understand that as we're working to put these things together, we have a lot of obstacles to overcome. And I think also rural areas, not just reservations, are terrifically underfunded, so that when we need resources, it is a scramble to get them. So that when we're trying to get help for our victims and for the perpetrators, it's been a long time coming to be able to do these kinds of things. And we're working very hard with our partners to try to stem the tide and to say, no more, no more. But you have these things to overcome. And one of the things that I want to make sure that people realize is that we are partnering with the different law enforcement agencies, but I want to make it really clear that the other agencies, although we're offering their ability, them the ability to call us for us to issue EPOs, that when they do that, as opposed to when they call a Superior Court judge, is really a decision, a policy decision that is going to be made internally in their agencies. We are going to be available for some of this help to assist the law enforcement agencies that we work with, but it, generally speaking, is going to be the call of their department when and who to call. But what we want to emphasize is somebody is going to be called. We're all done with this. We don't want to live like this in our shared communities.
And I actually recommend for everybody, not that, if for reading in terms of really truly understanding domestic violence and what it can do and how it even looks, because there is no one look to it for individuals and families, and what the victim is going through during this whole process is the book No Visible Bruises. What we don't know about domestic violence can kill us. I put a quote in it, and I only recently, I've been training bench officers here in San Francisco for many years, and this book came out. I read it a couple of years ago, and I was just struck. They studied a number of cases where there was lethality involved, and trying to say, well, how is it that we didn't see it? And I would encourage it if you have the opportunity. So next, which we're going to move into a different area, we are going to briefly discuss jurisdiction, which tribes have laws, the purpose of EPOs and the grounds for their issuance before we move on to the actual mechanics. So in California, the jurisdiction in Indian country is pursuant to Public Law 280 as it relates to domestic violence. We put together, actually, Judge Abby helped put together this chart. Very simple to take a look at in terms of the jurisdiction for being able to issue emergency protective orders and protective orders in general. You pretty much, the Yurok code, which is I'm going to relate to Yurok, but there are other tribal codes, is in chapter 10.15. And anytime either the victim or the offender, there is someone who is in Indian, then the jurisdiction is concurrent. The point of this slide and the point of this training is to know that we're in this together, that the jurisdiction for domestic violence in these situations is concurrent. And so it's not a matter if you do have an Indian involved in an altercation that law enforcement responds to, then you shouldn't think twice about the fact that you could call and should in certain circumstances, not just state judge, but contact the tribal judge and see if the tribal judge is going to issue an emergency protective order under the situation. So it's something I can't stress enough, that the jurisdiction is concurrent. It's not about competing in that sense. So you can move to the next, just that it's concurrent. I can't stress that enough. Just briefly, which courts, tribal courts have laws on EPOs and will issue them. As Judge Colgrove mentioned, she has not issued one, and the laws have been on the books for quite a while. But I think this is the beauty of this training, is to be able to make sure that tribes who either don't have laws can now put them on the books, but those that do now will have tools to develop their forms and institute a mechanism that's very similar to the state. But the Blue Lake Rancheria, the Hoopa, the Karuk, and the Yurok all currently have laws with regard to EPOs in particular, emergency protective orders, as opposed to your domestic violence restraining orders, or the ones that Ms. Fleming was talking about, the different types. And so these, and I expect, hopefully after today, that there will be more tribes, and then it becomes really a seamless, whether it's state court, tribal court, in terms of the process. Yurok, the Yurok's code has, in the forms they've developed, they again look very similar to the state form. So law enforcement, when they see the form, it's actually going to be very, very similar. Something that they should be, if for those law enforcement that have been on the force for a while and you've contacted state judges before, it's really going to be no different. So just in general, in terms of emergency protective orders, what's the purpose of an emergency protective order? Essentially, it's to provide immediate protection in the short term. It's just to give the victim enough time so that they can get paperwork together to be able to file in court for a longer restraining order. It is issued what we call ex parte. There's no hearing, there's no listening, for the judge, from the perspective of the judge, they just are going to get the information that the law enforcement officer gives them. Law enforcement may have had the opportunity to speak to both sides. They may only have the opportunity to speak to the victim. The perpetrator may have fled. So it's limited information, and the law enforcement officer will be contacting the judge directly. What I say when I train for the judges, and what I impart to the law enforcement, don't not call just because it's 2 a.m. We used to have a problem years ago when they would wait until shift change or till 8 a.m, not wanting to wake up the judge. It's our job. And if there is a domestic violence situation and it warrants somebody taking a look and making a decision, call. Safety is more important than sleep. So the California Family Code, the authorization, I've just put the statute up there, and I also put Yurok's code. So both of those laws authorize the officer to seek an ex parte where facts are presented, again, for the reasonable grounds to believe that a person, and this is the next slide, a person is in immediate and present danger of domestic violence, child is in immediate and present danger of abuse or family of or a household member, and a child is in immediate present danger of being abducted. One of the things that I think may be a misnomer is that emergency protective orders can only be stay away from the person. Emergency protective orders, as generalized protective orders, restraining orders, can include temporary care and custody of children in common. So even though you may have, and I believe Ms. Fleming touched on it, you may have an order out of family court that says custody goes to dad and mom gets visitation, or vice versa. And when you're in an emergency protective order situation and the law enforcement officer gives facts to the judicial officer, and there are children in common, the judicial officer is going to have to make a determination in that limited, immediate, short-term time who should be assigned the care and custody of the kids. So the fact that that's in an order doesn't disqualify it from being like, you don't take a look at it and say, well, that's not an emergency protective order. It's got too much in it. But you can also, at least in California, and I believe in the Yurok, correct me if I'm wrong, you can get an emergency protective order for stalking in California and for elder abuse, but it can be physical only. As you know, we do have elder abuse financial, but in terms of an emergency protective order, it's the physical. It's the physical violence aspect. And in California, and you may see down the road in tribal jurisdictions, we are allowed to issue emergency protective orders for gun violence restraining, taking guns away. Now that's a part of emergency protective order being granted, then guns actually can be seized and taken away. But there is special forms for an emergency gun violence restraining order. Not yet that I understand in tribal, but they may be looking at that. So keep an eye out for that. Should they authorize and have those forms, then again, it would be the same, enforce them immediately. There is that required relationship with regard to the grounds for issuing it. It's not just, violence between neighbors. We're talking about a required relationship of a spouse, an intimate partner, a dating partner, or the people just share children in common. So this is general. I'm going to do one more slide and then we'll move on to the next area. But one of the most important things about emergency protective orders for law enforcement and judges is recognizing and understanding DV when you see it, and learning to recognize what abusive behavior is, asking the questions. So getting that information, and Jake, you can keep going. Asking the questions for what's the relationship between the parties, because if there is no relationship, the judicial officer is going to say, that sounds horrible, but I'm sorry, I'm going to have to decline to issue. It does not fit within the requirements of issuing an emergency protective order. Getting that background information of prior incidents and weapons and things of that sort is so key, because we get so little information. We are relying upon law enforcement to get as much information as they can within the time frame they have, understanding it's a volatile situation, so that we can make an informed decision. So capturing those details are so important, and we'll talk a little bit more. We actually have specific scripts and things for you to look at. And that another quote, again, I found this in the book. It struck me when I read it, is unlike any other crime where, assault, sort of in terms of theft, it happens on the spot. Domestic violence can be in brewing for years. It doesn't happen in a vacuum. And while you may be responding to one particular incident that on its face, maybe initially you respond and it doesn't seem like it's more than a spat, and maybe someone, and I don't, it didn't seem like it was a big deal. When you do you ask your questions and go through the script that we'll be working with you, you find in fact that there may be 16 other unreported incidences of domestic violence. And the victim is, this will be the first time that they're telling you, if you ask that question. And they may never have called the police before, and this might be the first time you're responding. It might be, and I've gotten cases when I've been on EPO duty where the officer will tell me, yeah, this is the 10th time we've been out here. And, the fact that law enforcement knows the individuals is great. But again, I need to know that information because it helps me. It's one piece of information to help me assess, is this going to be one of those where it's really an emergency and I need to issue the order. So we're going to move on to another area to actually, which is the meat of this, is getting to the mechanics of it. So how do you get an EPO, and how are you going to get it from the tribal court? Well, how do you do it now in state court? It's very similar. Essentially, you're provided a mechanism to contact the judge. We used to have a pager system years ago here in San Francisco. We went from that. We now have an answering service. So it's one phone number rather than the law enforcement having to check a weekly schedule of who's on duty. We obviously have more judicial officers. We all take turns. So the mechanics is in terms of you call day or night. And again, don't hesitate to call at 3 a.m. if it's a situation you're responding to and there's been domestic violence, or it appears that there's been domestic violence. So you're going to be then communicating the information that you gather that will be going over the scripts and getting that information. And then you're going to let the judicial officer will tell you they're going to either decline to issue, and you're just, going to get their name and put it in your report and you're done. You're not going to do an EPO form. Or if they're going to issue the emergency protective order, then you're going to have to complete the EPO forms and serve them. The sheriff was I'm glad they had a slide on the service issue is very important. If the parties are still on the scene, you obviously want to try to get it filled out and served immediately on the spot. If the person has fled or they've been incarcerated, arrested, you want to serve them before they get released. So that part. And then to the extent that tribes have the ability to enter into the DOJ and CIC, or the law enforcement has the ability, then entry into CLETS. That's not a requirement for the validity of any of the tribal forms, but again, that's sort of the mechanics of how it works, so that if it can be entered, then that is one more piece of information where officers do check and they'll see if there have been any previous reported incidents put in. So in general, we will be looking to the forms in a moment, but I wanted to briefly have you look at the questions that one side gives to the other and the other side gives back. Let's look at what law enforcement needs to communicate. And these are just some generalized questions that you're going to need to communicate. So where do you get that information? Mostly from the victim, or you can talk to both sides. So what is the relationship of the parties? Do they live together? Do they have any children in common? And what happened? That's key. Any injuries? Usually if I don't hear and any prior history of DV, which is very important, whether it's reported or unreported, because unreported is just as important as reported in understanding and helping the judicial officer assess whether it's appropriate to issue an emergency protective order. And then of course, the results of any inquiry regarding guns. I'm going to harp on the guns. The judicial officer has the same script in terms of asking if the officer asked about guns. And then from the other perspective, and we will talk a little bit more, and I'm going to ask Abby some questions on what she would like to hear. But what does the judicial officer then need to give to the law enforcement? So the law enforcement is given all this information. The judicial officer is going to have to decide: is it granted, is it declined, or denied? And does there need to be a kick out order? Well, what's the kick out is the move out immediately, and we'll be looking at the forms. So we need to know if they live together. That's why that question in the previous slide is, we need to know whether we're going to have to instruct the officer to check a certain box on the form. Does there need to be temporary care and custody of children in common? So we need to know if there are children in common. If you don't ask, You might not see the children when you respond to a scene, but you need to ask the victim if they have any children in common with the perpetrator. The judicial officer is going to have to tell you in filling out the form when the EPO expires. It's generally for tribal protective orders, it's going to be the 7th calendar day. And that's in likelihood that most tribal courts, they don't necessarily have court every day. So these emergency protective orders do not last longer than 7 days. Again, remember the purpose: immediate protection, just enough time to help them get help from victims advocate services, justice partners, self-help, to get a restraining order in place if it's appropriate. And then to remember to direct the officer about asking about guns, and then you're going to give them your name. So we also are going to be, and then once it's issued, and this is just the general rule, and then we'll be going through the forms because I think it's really important. Once the the next slide, the tribal EPO is issued, then you're going to either enter it, if it must be entered into either DOJ and CIC. And Judge Abby, are you regular, or is that going to happen in the Yurok tribe?
What we're going to do now, we're meeting next week with our public safety, and we're going to make a decision about how that's going to be entered. We both have the capacity to enter it into DOJ. And so we're just going to talk about how that's going to be done.
Great. And this is an opportunity really for law enforcement, for sheriffs, for tribal police, for courts, judicial officers, actually on both state and for tribal courts, to talk about sort of coordinating these efforts as these systems get into place. But the distribution, one goes to the protected party, one to the restrained, one to the court. The court here, actually, I think we don't keep it for very long, but we do get a copy. One to the restrained party, and this is the key. Again, officer needs to serve it, because there will be going over the form. There's a place to where you are going to fill out your proof of service, and then one for law enforcement. So there is also a victim referral card, which we will look at later, that is given out, at least in our county, at every instance where an EPO has been issued, and even actually where it hasn't, to give help to the victim as to services, etc. So this would be a good time to actually look at the forms. And I think, Jake, if you can go to the forms for the law enforcement, since we have so many law enforcement, which is great. That's the judge's one. So there we go. What we've provided for you in your materials is literally sort of this. You don't have to do, ask every question. These are some these are good questions to ask, because if I don't hear some of the information, I'm going to ask the officer, tell me what happened, or do they have children in common if you forget. Don't worry if you forget, the judge will actually ask, and they'll have a script we prepared to make sure that we cover everything. But when you get to, scene, obviously everybody's safety first and foremost, but once you've dealt with the immediacy, obviously you're going to need names to fill into for the form, but the relationship, finding out that they're married, one of the things we look for, at least from a judicial perspective, is how long they've been together, and whether they've recently broken up. Because again, if you remember, being estranged is one of the higher levels of risk. And so I will get an officer, and just by way of example, that will say, yeah, I'm looking to see if an EPO should be issued. It's a boyfriend-girlfriend situation. They've been dating for 2 years and just broke up. So, but that's information, again, that law enforcement gathered before they called me to find out, again, the relationship, how long it was. And sometimes it might be a dating relationship just for 2 weeks and they broke up. But again, these are pieces of information that help us make an informed decision. You definitely need to know if children are in common. You definitely need to know if they live together, as I mentioned, because we need to know whether to give temporary care and custody of these children to somebody. What happened? The best way is, you guys, the law enforcement, you've done plenty of arrests, gone to plenty of situations and calls, and know how to gather information. These are just some of the suggestions and information If it's warranted, get the description, obviously, of any physical altercation. It's really important if you hear about any choking or strangulation to actually find out if there's loss of consciousness and get that information. That, again, is critical for a judicial officer to know in terms of how they're going to assess the situation. You know, I always ask if an officer doesn't tell me when they say, well, somebody slapped somebody, and I ask the question, not because I'm going to rule out an EPO, but any visible signs of injury, and because of the severity. Someone might say, well, they bit my finger. Well, did it leave any marks? As opposed to maybe the finger was practically torn off. Or if you can see redness, and I know officers, if they're gathering information, some will actually take pictures. But the fact that there's no visible signs of injury will not mean I'm not going to grant an EPO, or that the judicial officer shouldn't grant, but it's understanding the severity and what you see. But it's also important to know that in strangulation cases, et cetera, someone can have been had a chokehold on them, and you can't see it. So again, the fact that there's no visible, you might see redness on the neck in some instances. So getting any relevant statements as to what was said, that will help you flush out whether there were threats and suicide threats, et cetera, made. I always ask the officer, are there any prior incidents of domestic violence, and whether they were reported to the police or not. And that's where, again, you get great information, again, to give to the judicial officer so that they can properly assess the level of danger, as well as whether it's an emergency protective order situation. Asking about firearms, I mean, we'll probably see that many, it's a given. The gun, the presence of a gun, or the ownership of a gun is one of, and statistically and in past studies, is one of the things that elevates that risk that we talked about before. So one of the things I do, just because they live together and there is a domestic violence incident and the court is going to grant an emergency protective order, law enforcement officers, at least in San Francisco, often ask the victim, are you planning on staying? Because sometimes the victim has made arrangements to go elsewhere, stay with family members, to go into a shelter, to et cetera. So we don't want to issue a kick-out order if it's not necessary, but we also don't want to force or have the victim, if they have no place to go, of course they're going to be able to stay, and we want to make sure we issue a kick-out order so that she can remain in the living situation while the perpetrator has to stay away. And any other facts you observe. I actually don't always ask, but sometimes the law enforcement officers will, they have their own assessment. You guys have been out there in the field a long time, and sometimes you know it when you see it, and other times you have this sense as to the dangerousness. We're going to talk about the assessment in a moment. But if there's something that you think is important, by all means, make sure you communicate that to the judge. And then once you've gotten that information, oftentimes in San Francisco, they'll check the clutch, or they'll check to see if there are existing criminal protective orders or things in place, and they'll give us that information. That's when you pick up the phone, and the mechanics, you call 2 o'clock in the morning, doesn't matter, whatever, call so that you can get a determination from a judicial officer as to whether an emergency protective order should be issued. Of course, if the officer declines, if the judge declines, then you're writing up a report anyway from your, going out to the call. Then you just put the name of the bench officer in there, decline to issue, Judge Colgrove or Judge Abbey, and you're done, no EPO form. And then if they grant, that's when, on the flip side, the judicial officer is going to instruct you as to the items, and then you serve and keep copies. I'd like to take a look at the form, Jake, the next in this PDF, page 2. So this is what the emergency protective order for Yurok looks like. For any law enforcement that's been on duty for a while, if they've been out on a call and had any state court issued protective orders, it's extremely similar. In fact, the numbers in terms of line items line up just with the EPO form that California uses. I know, when I get the calls, I already know if I'm going to grant, I'll say check boxes 3A, B, and C. It's the same here. And so you're going to fill in the protected person's name and the restrained person's name once the judicial officer has determined it's going to be granted. And then the judicial officer will give you specific instructions with regard to those items all the way up through number 8. So the judicial officer is going to tell you which boxes to check. The standard stay away order is the same, I would believe, and Judge Abby would be 100-yard stay away generally. And then checking, if you see 3C off to the right, you see that box that says move out immediately. If law enforcement hasn't given us information that they live together, I'm not going to know to tell them to check that box. So it's important that you, again, include that information so that I can determine whether I should issue what we call the kick out order. Generally, it's 100-yard stay away, but you will have situations where they maybe live in a apartment building or in live close together, or they work in the same place, or on a different floor. You can, and the judicial officer does have discretion to issue a lesser amount than 100 yards, or to indicate 100-yard stay away generally, and have you handwrite on the form. I've instructed officers sometimes, except when exiting or entering, for work, you have to stay 25 yards away, so that or when you're at work, stay 50 yards away. So again, the judicial officer will instruct you on what to put in there. If kids are involved, they'll instruct you on line 4. You just need the first names of the kids. You don't need their full names and their ages, and who to give temporary care. Generally, we will give temporary care and custody to the victim. Even if there are, and again, if there are conflicting orders and you know about them, let us know, because family court does say things. And I have had situations where someone attempts to abuse the process to try to get custody of the kids when they don't have custody and they're actually under supervised visitation. But again, that's why it's important to get information from in the situation. You can ask the victim, are there any orders in place, and what are they? So the order will expire again. It's generally going to be the 7th calendar day. Beyond that, that should be enough time to be able to at least file for a regular domestic violence protection order. Your responsibility is going to be to fill out the rest of the lines. So in the application, if you look on this form, the events that caused the protected person to fear immediate and present danger of domestic violence abuse. So you've given probably a much longer explanation to the judicial officer, but essentially that is going to be a summary of the incident. So-and-so, or the victim and perpetrator got into a verbal argument. The perpetrator, punched or whatever, just a brief summary as to what happened. And then that's what you put in line 9. And then of course you always ask about and look for firearms, and then check, you yourself will determine what to check there as to whether they were observed or the victim reported that they existed, etc. Then if you've asked whether a custody order exists or not, if you don't know, then you can indicate that you can leave that blank, or it does or does not exist. And then your name, your agency, your phone number, your badge number go there. The bottom part sometimes gets filled out at the same time if the perpetrator hasn't fled. Sometimes you may have to go back and fill it out if you're going to serve after you've arrested somebody. But it is really important that, and it doesn't have to be served by the same officer. So if another officer does the booking and they know that an EPO has been issued, they can fill out the bottom part and make sure, because this is what the DAs and the others are going to rely upon in terms of service if there's going to be a violation of an emergency protective order, that they need to know that the perpetrator had actual notice of this emergency protective order. This is a piece of paper. It's only as good as it gets around, and it's even then, as we all know, a piece of paper doesn't protect somebody per se who's bound and determined, but if it's not served, it's of no use. And so it's very important that if you can, to get it served as quickly as possible. I'd like to, we're going to look at, and I think it's going to, it's really, we'll, if we can wait, Jake, for the lethality screen, we're going to go back to that. I'd like to take a look at the forms for the judicial bench, because we have a few judges, I believe, in this program, and it's important that you can kind of see the other side of it. So for a judge, and when I give the training, it's I get law enforcement that calls. They've been doing this for a while. I don't even have to ask a question. I just say, this is Commissioner Whiteman. Do you need an EPO? And the officer will just start right into the relationship, what happened, tell me if it's reported or unreported, but I'll prompt them. So again, if you don't hear from the law enforcement, for those of you on the bench, if you don't hear some information that you would like to have, ask. Sometimes if they're still out on the scene, the law enforcement can actually just, the victim may be right there. Other times law enforcement has gone back to the station and they may not be able to get that information. And guess what? We have to make a determination with the best that we have. And so, but you do want to ask. I do value officers' opinion about whether they may be in danger, but that is not the end all be all at all. It is a piece of information that I assess when I hear the information. I do ask every time on the prior history, because again, having 20 unreported incidents in the past is very different than having, this is the first time it's ever happened. And then I think about the stage. Did they just break up? Those kinds of things, and what exactly happened. As a judicial officer, you assess whether to issue it. When I give this training, I have some hypos that I give, and my colleagues oftentimes, well, did they do this, or did they have, is there unreported? And in the hypo I didn't put, I said, you don't have that information. We still have to make the decision. And then if we're, as I said, declining, we give our name, we're done. But if we're issuing, and then again, flip side, we have to communicate. It's just a two-way street. Law enforcement, we depend upon you, and law enforcement will then depend upon us to help them to get these forms filled out properly in terms of the parameters of an emergency protective order. So we're going to then go through the same form and tell them to check boxes 3A, 3B, 3C, if there are kids in common, etc. One of the things I say this important for the bench, but also for law enforcement, sometimes people both live and work, and when it's 100 yards stay away, an emergency protective order, just like a restraining order, is good no matter where you are, right? So they have to stay 100 yards away from you. There are times where I will ask, and I know there are some forms that say fill in the workplace and the home address. I do point out, I'm a little leery sometimes where if the person also works and they don't want, or they're going to stay at their sister's and they're, they are afraid. I always ask the officer, does the perpetrator know where the sister's house is? Because if they don't, why would you put that address in to broadcast it? At least that's one way to look at it. Because now if they do, obviously, if the perpetrator knows where they work and knows where other family members are, and that may be where the victim's going to stay, absolutely nothing wrong with putting in more than one address in the line of stay 100 yards away from. You have multiple lines there to put in addresses, but we don't want to broadcast an address or a place or a location where the victim is going that the perpetrator may not know. So because the 100-yard stay away is good enough, it should be good enough. So it's a little pointer for judicial officers. Judicial officers have, if you can go to the next slide, there's a cheat sheet that goes around. We call it a cheat sheet, but really what it is a bench officer here in California, I believe out of Santa Clara, has updates this every year. It gives us, for those in California, and the codes, again, tribal codes will be a little different, a way if we're being woken up at 3 in the morning and we just want to remember, make sure we do have the required relationship, etc. These are sort of legal code section and references of the things we can do and what we need to look for. And what authority we have. So it's a tool for bench officers that you have in your toolkit to reference. What I'd like to do next and would be just if we can go back to the PowerPoint and just ask a couple of or just point out a couple of things. And that would be on page 17 of the PowerPoint, sort of a what if. So one of the things I do when I train is to sort of ask a sort of, well, what if? Well, what if there are no injuries? And this goes for both for law enforcement and judge. What if there are no injuries? Well, that again isn't determinative. Law enforcement, just because there were no injuries, doesn't mean it can't be DV. So don't not call because again, as I said, there could be strangulation and you don't see any visible signs and et cetera. You want to call if there's any indication that there has been domestic violence abuse. And it also helps to know if children were present during any incident or if it was directed at any children, because we can then put the children actually in the protective area. But just because there are no injuries doesn't mean you don't call. The victim doesn't want one. How many times have I heard that? And the officer dutifully reports it because that's what the victim is saying. I don't want an EPO. I'm okay. Etc. Again, that is not determinative. Do not call just because the victim says, I don't want one. In fact, as we mentioned before, in terms of studies, oftentimes the victim doesn't even realize necessarily the level of risk or danger they may be in. And they may be, for reasons, the barriers of, fear, etc. It's a piece of information. I always ask the officer, and I'm glad they told me the victim doesn't want one, but it's not going to sway me not to issue one if the facts are appropriate. And just sort of well, who's the aggressor? We do have those situations. Law enforcement goes out, you hear two versions. You may have your own who to believe, but sometimes it looks like they both have been at it. And if it's impossible to figure out, again, give all the information you've gathered to the bench officer and let the bench officer decide. It is possible for us to actually instruct the officer to issue 2 EPOs. And if they both seem to be aggressors and they both are in immediate danger, and it again lasts only 7 days, so that is possible. We may instruct that. I've done that on occasion to issue an EPO for each individual. And they may not, if they're in the place, maybe neither of them can stay. They have to just stay away and stay somewhere else. So again, we've mentioned that the judge can tailor the distance. The real important thing about this training with regard to these forms and things is that communication and collaboration in this situation really are key. And so I would like to, Abby, sort of ask you, sort of invite you to speak a little bit about what you are expecting in terms of the tribal police and law enforcement, sheriffs, et cetera, when your system gets up and running.
Well, essentially what we're going to do is we're going to provide you, this is sort of like an introduction. You will have these packets in your car. You will have the instruction sheets. You will have everything available to you. And will be this that you're watching now will also be available if you need to have a sort of a review. This is an introduction, and the scripts are really helpful, and you'll have the script to help you through the phone calls, and the bench officers will also have the scripts, and we will tell you very specifically, this is what you need to fill in, and line 1, 2, 3, whatever. So that just looking at it in this sort of 1-hour presentation can feel a little overwhelming, but it's really not, because it's very highly scripted, so it's a really, here's 1 through 15 and you just do all the steps, and it can make a huge difference in the community in the sense of protection. And that's what we're trying to do. And also to be able to say to the law enforcement agencies who are working with us, and where we're cross-deputized and where we want them to understand that we respect, if they're out there doing that and, we're going to be dealing with it long-term, we will take our responsibility seriously and move in to work with it and try to provide services, because we have unique services also for our communities.
And what we're trying to do is address the problem. We're not trying to just create consequences. We're trying to create solutions, which changes the ballgame, because we want to protect the victim. And we also would like to have the behavior cease, because it's very rarely just one time, in the sense of, okay, well, I only did it to this person, I never do it to another person. Generally speaking, it can be serial, and a person moves from one victim to another victim. So what you're trying to do is create a situation where you can end the problem. And that's what we're trying to do. And the scripts, I think, are key to it. I think the packets are key to it. And the packets will have instructions. Here's what you do. Here's the script. And, here's how you do service. And the sheriff mentioned, if they didn't get served, when you run into them again, you can serve them right on the spot. And how will that be available to you? All of those things are going to be answerable. So I appreciate the time that people are devoting to try to learn this new service, but it is something I think if we work together, we can do and do well and create safety for our community and help people who need the help.
And we're going to cover one more point, because we have also an important demonstration I think that Cynthia will give, but there's a victim's referral card that we have in San Francisco, and I believe Yurok put together one. We're not going to do that just yet, Jake. The victim referral card, if you could bring that up. And it's, yeah. So anytime the law enforcement goes out to a scene in domestic violence, I will, especially if it's an egregious situation, I will indicate to the officer, have you given the victim's referral card yet? And on our card, victim referral card in San Francisco, there's a special community-based organization that helps women in particular, and they'll give a referral for men, because men can be victims as well. But they will actually help the victim prepare the paperwork for a longer restraining order, and they'll attend a court with them free of charge. So I'll have the officer circle back one in particular and say, make sure you give the victim's referral card. Yurok put this together. Every tribal, I would encourage tribal courts to put together their own, or if this works for the region, that's great. But that's something that should be included with law enforcement in their packet with regard to when they are going to be doing a tribal EPO. One last thing that I do want to discuss is it's short because this is really on EPOs, is to discuss the danger lethality assessment process. And that is the slide that you had up, Jake. It should be done anytime it's indicated. And this is the law enforcement's decision initially, but again, judicial officers as well, where it's indicated, where you're talking about highly dangerous situations, or you think that it might be. There is an assessment tool we have put in your packet, and it's a program, really. It's a two-step process. The officer gets on the scene. If they feel that there's a manifestation of danger, then they go to the tool. And if you could pull up, and then when they go to that tool, they ask questions. If it passes so many questions, they know then to give, the second step is to give the referral to one of the organizations, depending on the dangerousness. Jake, if you could pull up the lethality for the first responders, it's in the law enforcement packet, and it's, I believe, the third page. So we've given this to you. This was developed by Dr. Campbell, and it takes less than 5 minutes. When you do have one of those manifestation of danger situations, you can do really a great service to the victim with regard to, again, because oftentimes they don't realize what danger they're in. These questions have come from studies that when you have yes or no answers, when you have yes answers, certainly to one of the first 3 questions there, using a weapon, threaten to kill, then you're going to move to the next step and make sure that victim is given proper referral information. They don't have threats, etc. There's these next set of questions that, again, it takes less than 5 minutes to do. If you get a certain number of responses on there, you're going to want to go to the next step and give a referral. And to law enforcement that doesn't have this, I would encourage you to work with community-based organizations, victims advocates, and make sure you get a system in place. that you want to do that, because you can then prevent potentially homicide victims down the road. We have a similar, and if Jake, you could pull that up for the judges. On theirs, there is a bench guide for recognizing dangerousness, similar questions, but not the same. So judges, in whatever assignment you are in, quite frankly, doesn't have to be family law, and it's not dealing with EPOs. Depending on what you're dealing with, if you have this sense that it might be a dangerous situation where you between litigants, you might want to institute or use this tool to see whether it's going to inform you as to what kind of decisions or limitations or things you might put in decisions. Usually it is going to be in the DV court or the family court, et cetera. But even when you're in, in another court, if you can see, you might want to consider giving a referral once you go through these questions. So that, it's really in a nutshell. In terms of we can't stress enough how important it is to work together. And after you've seen this video, or now that you've heard this, start working on getting together to have a more contact and connection and getting the packet forms together. There is an upcoming webinar, Jake, next to the last slide, we did want to advise you of, that's coming up, which is an NTCC webinar coming right around the corner on June 3rd. That information is in your packet. It's free, and I would encourage everyone, and I think Michelle I don't know if she'll say anything about it, but please be sure, if you have the time and ability to do it, and I assume hopefully it will be also recorded, that maybe you can look at it later. I want to turn it back and thank you all very much for giving me the opportunity to at least get you an introduction here to EPO process. And if you have any questions, I'm actually willing to make myself available, whether if law enforcement has questions or otherwise. Judge Abby can refer, or she can be in touch with me through email. Thank you all.
So speaking of resources, NCTCC has developed a mobile app that can be downloaded on your cell phone or tablet. It is a self-help resource for tribal victims of crime, and it is the only tool of its kind. Now, it has been created by Native people for Native people, but I do want to emphasize that this app is a victim-centered app. It contains a wide array of resources that are being used by both Native and non-Native victims alike. The reference card that you see here is a quick index to the app's contents, and if you're curious, it's available to print. You can carry it in your pocket or in your wallet, and you can also give printed cards to victims. So if you'd like some printed cards, please contact me. I think when Jake gets a free moment, he'll probably drop my email address in the chat box. And so we're going to flip to the home screen now so that I can show you the 6 links that we have included. We have tribal justice resources, safety, self-care, California and national resources, and my rights, and also criminal justice system explained. So I'm just going to breeze through this, kind of give you an overview and let you see what's inside the app. It uses a card type format to present information, resources, and tools. So on the next slide is an example. On your left, you will see the menu for criminal justice system explained. And on your right are scrollable information cards in that section. So each section includes a subsection and then scrollable information cards like this. So on the next slide, I want to show you what tribal resources look like. We include victim service providers, tribal social services, law enforcement, tribal court, and other departments for each listed tribe. This is because we recognize that each tribe is unique and each tribe will have its own set of resources. On the next slide, you see California and national resources. This provides similar information, only it's for the California and Oregon counties that are listed. And we also have some national resources for you. These contain a wide array of resources for at-risk populations, such as Asian Pacific Islander, African American, children, elders, LGBTQ and other populations. Because individuals in tribal communities often identify in multiple ways, our goal is to empower victims to find services that are appropriate and comfortable for them. So I think we can go to the next slide. These show the resource cards that are contained in each tribe and county and national resources. They contain key services and offices in each jurisdiction that you can contact for more information, mainly phone numbers and websites. Next slide, the safety section includes information resources, checklists, and fillable forms for many situations, and these also can be printed. On the next slide, you're going to see safety plans that are available. We have safety plans for stalking and harassment, elder abuse, cyber safety, and more. These can be filled, and as I said, they can be printed as well. Another section that we have is the self-care section. The self-care section contains information on trauma and imbalance and tools to help victims restore balance. Survivors can learn how their victimization might trigger historic trauma, what causes imbalance, ways they can ways they can restore balance, and also you can find a checklist of self-care suggestions in this section. The next slide is going to show you the My Rights section. This section contains a good basic primer on victim rights, how victim rights can be enforced, and what exactly victim rights are. The next section is the final section I'm going to talk about. It's a section on the criminal justice system, and it contains both information and a tool that helps victims decide in which jurisdiction to report. So next slide, please. Victims can learn how the process works from entry to exit. And because choosing to not report triggers a different process than reporting, this section will help victims know what to expect throughout each step of the process, depending on what they choose to do. The Where Do I Report tool is a sort of simulator, and it walks users through PL 280 jurisdiction issues step by step. And just as a reminder, this tool is not meant as legal advice. It's just kind of a guide, and victims really should speak to an attorney if they're dealing with PL 280 issues. So that is a whirlwind tour of our app. I just want to let you know that NCTCC just released an updated version of the app that includes COVID resources. And we are currently working on another release that will be available at the end of the summer. So thank you so much for your attention. I want to let you know that my team is available to demonstrate the app to your staff if you would like that. And you can contact me if you have questions or would like a demo. Thank you so much for your attention today.